Hello, good day. Yes, you are watching the Employment Law Show. So good to have you on the show today. 30 minutes. It's going to be pretty interesting. You will guaranteed to be learned a lot. If you have a job out there, if you work, if you're one of those people, like all of us, you're going to need this information, right? We always try to educate you each and every week. Reaching out to Lior Samfiru right here, co-founding partner, Samfiru Tumarkin LLP, is really, really simple. Phone number first, 1-855-821-5900. You want to send along an email, we'll get to some of those on the show today. help@employmentlawyer.ca. And a website we're very proud of because everybody goes there. They always learn lots, and the severance pay calculator is also baked into it, called pocketemploymentlawyer.ca. Save yourself a lot of strife and panic and wonder. Use the website at your leisure. Absolutely free and anonymous. Tons of stuff to learn there, and that severance pay calculator, as you know, can tell you exactly how much severance you're owed in just 30 seconds or so. 2 million plus people have used it in this country, so you know it's pretty much bulletproof. We'll get to that later on, an example of 5 significant employment law terms. That's what's coming at you today. You probably don't know these, or it sounds legalese, legal speak. We're going to clear that all up on the show in just a little bit. But the week that was, pal, case of the day, what do you got?
Well, John, it's certainly been an interesting couple of years, my gosh, in my office. I've been practicing law for some 20 years now, but the last 2 years have been just a whirlwind. We're learning things as we go, new concepts. We never had to think about the impacts of a pandemic on the workplace, the impact of vaccines on employee rights. What we're learning, we have learned, we understand these issues right now, and guess what? The law is still pretty darn good. We have such good employment laws in this country. Doesn't matter what province you're in, that protect you, that give you rights, that give you options. And a lot of people that complain that we don't have good employment rights, I understand that, but usually it's because you don't appreciate necessarily what our laws say. Well, by watching this show, you'll appreciate what the laws say. You'll understand, you'll know what your rights are as an employee and what to do if you're facing a workplace problem. Things are not always going to be great at work. It's not always that, you go to work, you give your boss a big hug, you get a nice big bonus at the end of the year. It's nice to think that that's always the case. It's not always going to be. So if things don't go well, if you're put on a performance improvement plan, if you're threatened with the loss of your job, if you actually lose your job, you'll know what to do. You'll know what you're owed. You'll know what the law does for you. That is the point of that show, of this show. And of course, if you want to connect with me off air at any time, you want to talk by email, by phone, you want to discuss your specific matter and what can be done to help you, easy to do. We'll give you that contact information throughout the show. We have a whole team across Canada that does just that, so stay tuned for that. But as always, to start off with the situation that came across my desk over the past week, and I'll put this in the category of something that I've learned a long time ago, which is you should always listen to your wife, okay? Hopefully she's not watching. But the reality is that this is a case that this gentleman, by listening to his wife, ended up doing something really good. So take a step back. This person started a new job, and in about day 89, I think it was, of his job, he was called into the boss's office and said, you know what, we're deciding to let you go. We don't feel things are working out. And because you're under probationary period, you've been here less than 90 days, we're not going to pay you any severance, but we certainly wish you all the best and goodbye. He thought, he was obviously upset, who wouldn't be, but he thought from a legal standpoint that that's okay. He was there for 90 days, probationary period, so he decided that there's not much that he can do. Well, luckily, and this is where the significant other comes in, his wife convinced him to give me a call. Said, what's the downside? Call Lior, talk to him, and if he says you're not owed anything, you're not owed anything, but at least you'll know. So here's the thing, John. This person never signed an employment agreement.
Right.
And because he never signed an employment agreement, he's not on probation. Remember, probation is not automatic. Probation has to be created in an employment agreement. So you're only on probation if you sign an employment agreement that says in the first 90 days, you're on probation and we can let you go without paying you anything. In this case, he never signed anything like that, remotely close to that. So he was never on probation. And why is that important? It's important because even in the first 90 days, if he's let go as he was, he is owed severance. So John, here's the shock for a lot of people. Even though he's worked there for less than 3 months, he's owed 3 months severance. 3 months, not weeks, not days, 3 months. And I'm helping him to get that, and it's not even going to be complicated. Remember, short service employees are treated disproportionately better than longer service employees. That's why you can get 3 months severance after only working for 3 months. And please, don't ever assume that you're on probation. take a look at your employment agreement. Grab it out of the drawer or wherever you keep it and read it. Does it say you're on probation? Does it say that during probation you can be let go without any compensation? It's only if it says that can happen. If it doesn't say that, or if you've never signed an employment agreement, you're not on probation and you're going to be owed severance even if you're let go shortly after you started.
Why are short service employees disproportionately handled better when it comes to severance? Why is that?
Well, we have to think, what is the purpose of severance? The purpose of severance is not to punish your employer for letting you go. The purpose of severance is to help you while you're looking for another job, while you don't have other income. Well, just because you work for a company for a short period of time doesn't mean you're going to take very little time to find another job. It's still going to take you a while to find another job, and in fact, it could take you even longer, because you're going to have to explain to the new employer why you only worked for the previous company for 3 months. So it's because of that severance for short service employees is still quite substantial. It's still measured in months. So you may have worked for a company for a few months, a year, 2 years, and your severance is still going to be a lot, potentially 6 months, 8 months, 9 months, even for a short service employee. And by the way, if you're not sure what you're owed or if you're owed, you know what to do. You give me a call.
If I'm an employer, can I say, 3 months probation is great, Lior, but I want to put all my future employees on 6 months probation? Can I do that? Does that affect severance? Does that affect what I can do, how I do it?
So if the goal of the employer is to have a period of time during which they can let the employee go without any severance, that period cannot last longer than 3 months, 90 days, okay? Under employment standards legislation, the period of time during which the employer is allowed to let you go without severance is 3 months, but of course, only if that's what your employment agreement says. So if the employment agreement says we can let you go in the first 6 months without paying you anything because you're on probation, that's illegal. That's not even going to be worth the paper it's written on, because it's a breach of employment standards. So as a practical matter, a probationary period can only last for 3 months, but again, not automatic. Only if you sign an employment agreement that specifically says that.
And if you go to another job, if you're induced to go to another workplace and they say, we're going to put you on probation, should you accept that? Because they came to you.
Well, I mean, you can accept that.
Right.
There's nothing illegal about that. But as a practical matter, why would you leave a secure job where you were recruited away from that job to start a new job and only to be on probation? Makes no sense. I would never agree to that. And I would tell anyone, if you're going to be recruited from another job, make sure you're not agreeing to be on probation. Make sure that it says that there isn't such a thing. You don't want to be on probation after leaving a secure job. And I think most employers that hire you will understand that.
Employmentlawyer.ca, website right there. You'll catch all the firm information there. Lots of stuff to be learned. Reach out for contact. There's also a media tab where you'll find a radio station somewhere across this country that's been carrying our radio show for many years that Lior and I, as some of the other lawyers at the firm, host every week. We got a ton of phone calls. People want to know things they learn on this show, and they reach out to do so. We play them back here, and we talk about them. First phone call from one of our radio shows coming up right now.
I worked for a small company, and there was only 4 of us working there. And they eliminated my position. I'm 64. I have some health issues that make it hard for me to find a different job. But I'm wondering what kind of severance I should have received.
How long did you work there for?
13 years.
And what were you doing there?
I was a secretary.
What did you receive?
3 months.
Ooh, a little bit shy.
Yeah, a little bit shy, quite a bit shy.
Yeah.
So one of the factors that are going to go into deciding how much severance you're owed is, do you have a medical issue that may prevent you from working somewhere else or looking for another job? Because arguably, if you're completely healthy, it's going to be easier to find another job than if you're struggling with your health. You may not be able to work, or you may be limited in what jobs you can take, or even in your ability to look for work. So if this lady has health issues that prevent her from finding another job, that means even more severance. But frankly, John, even if she was perfectly healthy, getting 3 months of severance after about 13 years of employment, that's not even close. So how much is she really owed? Well, rather than me just tell you, which I can easily do, let me show you. Let's go to pocketemploymentlawyer.ca. Let's use our severance calculator tool, which, as John said, has been used over 2 million times. So let's use our severance calculator tool. Let's see how much this person is owed if we were to plug in her information there. So she's in a secretarial role, been there for 13 years, 64 years old. Now, as you can see at the bottom, she's owed right around 16 months pay, 16 months. Now, that said, John, the fact that she is sick means that she could potentially be owed even more than 16 months. 16 months may actually be quite conservative for her. She could be 18 or 19 months. But either way, that's a lot more than the 3 months of severance that she was offered. And this is not something that is that unusual. Every single day, my team and I talk to dozens of people a day that have been let go and have been offered pennies on the dollar. This is just an example of that. So chances are, if you lose your job and you're staring at that severance letter, the amount that you're offered is also a lot less than what you're owed. So do the right thing. Give us a call or go to pocketemploymentlawyer.ca and use the severance calculator.
It's interesting, those factors, too, because you mentioned her age, her length of employment, and the fact that she had a medical condition. Now, she was a secretary. That's great. Standard job, no problem. Should probably be able to get another one of those jobs. But what if she was a fiduciary, CEO, a very rare position, in media, for instance? I mean, would that increase the amount of severance she would get?
So any factor that may impact your ability to find another job is a fair factor to consider for severance. So if you're looking in an industry where there's just not a lot of jobs, that means more severance. Or the type of job that you're looking for is one that there's not a lot of hiring going on for, more severance. On the other hand, if you're working in a type of industry or a job where there's a lot of demand out there, you could find the job easily, that's going to reduce your severance. Now, the fact that she may have been in a secretarial role, in and of itself, she may be able to replace that. But she's also in her mid-60s. That may be harder to find a job in the mid-60s. She's also not in perfect health, so that's going to be more difficult. So all those factors are going to point to a longer amount of severance, or a longer severance period, which is why I think 16 to 18 months for her is appropriate.
TerminationQuestions.com, another website you can use anytime to ask questions. Lior and his team get back to you rather quickly with full and complete answers. You can always reach out by phone at that point. First one for today, Moira writes in, says, I was recently presented with a new employment contract. Despite working for the company for almost 6 years, I've heard that employment agreements can contain clauses that could affect my rights if I lose my job. Do I have to sign this?
Okay, John, where's my soapbox so I can climb on top of it and start preaching here? But no, this is one of my biggest pet peeves, and it's a surefire way to give up your rights by signing a new employment agreement. If you're already an employee, if you have a job, and your employer comes to you and says, sign this new employment agreement, bad news, always. I can tell you without reading a page of it that it's bad news. Your employer is not going to ask you to sign an employment agreement unless there's something in it for the employer. So let me give you a few examples of some of the terms that could be problematic that you don't want to sign. Number one, it could be a term there that limits your amount of future severance. That could cost you tens of thousands of dollars. It could be the difference between getting 2 months severance and 24 months severance. Almost guarantee that the new agreement has that. There could be a term that allows the company to lay you off temporarily. The company doesn't have a right to lay you off temporarily unless you sign an employment agreement that gives them that right. There could be a term there that allows the company to change your job description, to change your hours of work, even to change your compensation. All of those things are things your employer is not allowed to do legally unless you gave them that right by signing an employment agreement that gives them that power. So those are a few examples. There's a lot more of things that are problematic, which means you do not want to sign that new employment agreement. You cannot be forced to sign it. You cannot be disciplined. You can't be suspended. You're not considered to have resigned. You can simply say, no, I'm not signing it. I'm comfortable with the agreement that I have. At a minimum, if you're presented with a new employment agreement, let me see it. Okay, send me a copy. I want to understand it, and I can tell you what it means and what it does. If it's fine, that's great. It's fine. But the likelihood of it actually being fine is very small. There's a reason you've been presented with it, so be smart. Don't just sign.
Even if it is something you want to go ahead and sign, if it gets your approval, don't they have to give you something for doing so?
Yeah, arguably for a new employment agreement to be enforceable, your employer has to give you something in return for signing. Right. It could be a one-time signing bonus. It could be a pay raise, extra vacation, anything that you wouldn't have otherwise been receiving. So strictly speaking, you could have signed it and it could still not be enforceable. While that's true, the best advice I'm ever going to be able to give you is if you don't agree with something, don't sign it. Don't assume that you can get out of it later. Yes, you may be able to, and we may have to do that. But in an ideal world, we don't even want to have that fight. If you don't agree with it, don't sign it. And remember, you can't be punished for not signing a new employment agreement.
Could this also be, since you're already working now, the employment agreement's been slid across the table towards you? Could that be a precursor of they're maybe thinking of letting you go in the future and kind of cut down on how much severance they have to pay by forcing you to sign that?
Well, think about it, John. An employer may say, okay, if I want to let Bob go today, it's going to cost me 18 months pay. That's a lot of money. But wait a second, if I haven't signed a new employment agreement and a couple months later I let him go, all of a sudden, instead of 18 months, I have to only pay 8 weeks pay. I've just saved myself $100,000. Wow, what a good idea. So yeah, that may be what an employer may try to do. Now, I'm not suggesting that your employer is doing that, but it's possible. And the fact that it's possible is something that I'm concerned about, and you should be concerned about it as well. So again, bottom line, if you're, as John says, have an employment agreement slid across the table to you, before you sign it, send me a copy. Let me read it. Let me tell you what it means, what it does, and at least then you're informed.
Short break, lots more coming up. 5 important employment law terms you need to know. That is coming up. In the meantime, the number to reach out to Lior and the team, 1-855-821-5900, and that email address, help@employmentlawyer.ca as well.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, welcome back. Employment Law Show. As mentioned just before the break, 5 employment law terms that are really important. There's actually like 1,005, but we're going to narrow it down to 5 for the purpose of the remaining time in this show. Number 1, let's get to it. Duty to accommodate. What is that?
So the duty to accommodate, it's under our human rights laws, and it's one of the most important obligations that an employer has. And what the duty to accommodate is an obligation that the employer has to provide you support and help in certain situations. The most common type of duty to accommodate is with respect to a medical issue. So if you have a medical issue, your employer may have to accommodate, to support you by giving you modified duties or modified hours, by giving you the ability to work from home, all depending on what your doctor says is needed. But there's other duties to accommodate. There could be accommodation based on family status. That means your employer has to accommodate your child care or family care responsibilities. Again, maybe giving you some flexible hours. There could be a duty to accommodate based on your religious beliefs. That may mean if you have to be at a synagogue or a mosque, let's say on a Friday afternoon for religious reasons, your employer may have to give you the flexibility to leave work at a certain time to be there, as long as it's legitimate and you can show your employer that that is something that is required of you for your religion. So this duty to accommodate is an extremely important duty, and if an employer doesn't meet that duty, then that becomes, it's a failure to accommodate, it's a human rights violation. And John, our employment laws, our human rights tribunals, our courts look at that very harshly.
Employment law term number 2, you got to know termination for cause, without cause.
So there's really only 2 types of terminations. The most common termination is a termination without cause. Termination without cause means you're let go for any reason, and you can be let go for any reason as long as you get paid severance. So a termination without cause is perfectly legal so long as your employer pays you severance. So some people hear this term, termination without cause, and they think that the employer may have done something wrong. No, that's fine, but proper severance has to be paid. The opposite of that is a termination for cause. Termination for cause can only happen if an employee is guilty of very significant misconduct, if that misconduct is repeated, and if the company has done everything they can to fix the problem. If they can't do that, then it becomes a termination for cause, and that means your employer does not have to pay you any severance. They can just let you go. So really the difference between a termination without cause and a termination with cause is severance. Keep in mind, of course, John, that it's very, very difficult to establish termination for cause.
Term number 3, tons of confusion around this one every time, independent contractor.
So an independent contractor is someone that's in business for himself or herself, someone that's running a business, not someone that works all the time for another company. So the question is, are you working for yourself or you're working for someone else? So if you have a number of customers or clients that you work for and you decide how much work you're going to do and you decide where you're going to work and how much you're going to charge, you're going to be an independent contractor. That means that you pay your taxes as an independent contractor, and it also means employment laws don't apply to you because you're not an employee. On the other hand, most people are in fact misclassified. They believe they're independent contractors, but they really have a regular job. They don't have a bunch of customers. They have to do what their boss tells them. In that situation, you are an employee that's simply been misclassified. That means you have the rights of an employee, including overtime, vacation pay, termination pay, severance, and you're simply not getting them because your employer is doing something wrong. So always ask yourself, if you want to know if you're an independent contractor, am I in business for myself or do I have a job? If you're in business for yourself, independent contractor. If you have a job, employee.
Okay, our next employment law terms, you got to know these two. I still screw up after 10 years, okay? Constructive dismissal, wrongful dismissal. Let's tackle constructive dismissal first.
So constructive dismissal is a dismissal that is actually constructive. No.
Done.
Done. Next question.
That's right.
No, a constructive dismissal is a situation where the law considers your employment as being terminated. The law considers you to have been dismissed, even though the company has not let you go formally. And why would the law do that, or when would the law do that? The law would do that in a situation where something happened to your employment. Maybe your pay was reduced. Maybe you've been demoted. Maybe your hours of work have changed. In all those situations, the law says, employee, your employer didn't have a right to do that. And because of that, you can choose to treat that as a termination of your employment. So we call it constructive dismissal because it's different than a regular dismissal. Constructive dismissal happens when you're facing a change to terms of employment and you choose to look at it as a termination. That means your employer has to pay you severance. If you ever find yourself in that situation where you're not sure if it's a constructive dismissal or not, do I have rights or not, give me a call before you quit, before you do anything, because we have to do it right. Now, the other aspect of this is a wrongful dismissal. A wrongful dismissal is usually a situation where the company lets you go and does not pay you proper severance. So it really has nothing to do with why you were let go. It has to do with severance. You could have been let go for the most amazingly legitimate reason. You could have been let go because the company is shutting down. And you could still be wrongfully dismissed if you're not getting proper severance. And over 90% of people, John, are actually wrongfully dismissed when they're let go. So wrongful dismissal has nothing to do with the reason. It has everything to do with the amount of severance that you're owed.
These terms, I know they can be confusing, especially if you're new to the show. Pocketemploymentlawyer.ca will clear so much of that up because they're there and it's easy to read and for you to digest in that particular fashion. But we'll get to another phone call number 2 from one of our radio shows right now.
I worked for a company for about 20 years, great company. They have a code of conduct policy that we review and sign off on every year. In that policy is conflict of interest and moonlighting. I've been offered a position, a contract position, to another company in the same line of work. I want to be able to do both and please everybody without getting fired or whatever.
So it's a great question, and it's actually a more common situation than you may think. So here's how this works. If you're going to work for your employer and also have another job in a similar line of work, that's a problem. Your employer may consider that to be a conflict, and your employer may consider that to be something that where you potentially are breaching confidentiality, even though you're not, and that can lead potentially to a termination for cause. We talked earlier about a termination for cause, i.e. without severance. So now it's very different. If you're working at a health food store and in the evenings you're working at McDonald's, that's going to be okay because there's not going to be a conflict there. But if you're working for 2 companies in the same line of work, that's a big problem. So what do? Well, you tell your employer and you ask your employer, can I work? Are you okay if I work with this other company? I'm going to maintain confidentiality. I'm going to maintain my hours of work here. My time working for you is still going to be dedicated to your work. It's not going to interfere, but I want your permission to work there. If your employer says yes, you're fine. You're golden. But if your employer says no, at least then you know that that's a problem. But what you don't want to do is try to get away with it. You don't want to take this other job that's kind of competitive and hope your employer doesn't find out, because if they find out, not only will you be sued for wrongful dismissal, you could potentially be sued for, not for wrongful dismissal, you could be let go for cause, you could potentially also be sued for other damages. So it's a bad thing to do. So always be honest with your employer if you're going to take a second job.
Phone call number 3 is coming up, but after a short break, which we'll do right now. The phone call to reach Lior and his team, 1-855-821-5900. PocketEmploymentLawyer.ca is the website we always plug, and the email address is help@employmentlawyer.ca. We're coming right back.
People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, welcome back. Employment Law Show. A few minutes to go here. As always, we like to refer to some of our phone calls. You want to find a radio show near you across this country where Lior and I and some of the other lawyers of the firm broadcast every week. EmploymentLawyer.ca is the source for that. Let's get to that third phone call right now, Lior.
I'm a tradesman. I've been with the company I'm with for about 3 years now. I've been temporarily reassigned to a different position. The position itself is not remotely related. I mind taking this position temporarily, but how long until it would be really considered, I guess, a constructive dismissal?
Time is of the essence.
Yeah, so, I would say this. If you're put in another position for more than a couple of months, then it's a constructive dismissal. But, okay, and this is the key here, if it's supposed to be temporary, you want to have confirmation in writing from your employer that it is only temporary. Because if you started this new position believing that it's only going to be for a few weeks and it continues on and you haven't said anything, you're going to be considered to have accepted it, and then you're stuck. And even though you thought you're going to go back to the old position, you're not going to be going back, and it's not a constructive dismissal. So if your employer says, listen, Joe, we're going to put you in a new position for a little while, write them back and say, I'm only going to agree to this for the next month or 2 months because you told me it's temporary, and then I want to be back in my old position. If you go back to your old position after that month or two, great. If not, you're still able to say constructive dismissal, okay? So keep that in mind. Always say that in writing. If you continue working and taking your employer word for it, you're compromising your rights. You don't want to do that. So you have to be very, very careful here.
What's the threshold? 2 months, 3 months, and it's like, hey, it's your new gig.
Generally speaking, anything more than 2 months, you're stuck with it unless you can show that there was an agreement for a different period of time. But bottom line, even if it's only going to be for a week or two, confirm with your employer in writing that it's temporary. Confirm with your employer that you're going back and you're not agreeing to it beyond that period of time. You don't even need your employer to agree to confirm that. It's just important that you said you've only agreed to it on a temporary basis.
Writing is so key. Get everything in writing. Right?
Always. If it's not in writing, it doesn't exist.
You got it. That'll do it for another show. Reaching out now that we are done. Simple phone call, 1-855-821-5900. The email address we always use is help@employmentlawyer.ca. The website, PocketEmploymentLawyer.ca as well. And I mentioned TerminationQuestions.com, another resource for you to ask questions anytime to Lior and his team. Thanks so much for tuning in, and we'll catch you next time on the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.